Can the guardian of a minor be permitted to dispose of the assets of a minor? The Supreme Court in Shepley Chakraborty v. State of West Bengal recently answered the question in the affirmative subject to certain conditions, and held that the ultimate test in such cases is whether the transaction is in welfare of the child. The facts are that mother of the child sought permission to dispose of the minor's share inherited at the death of her husband. A land was owned by the paternal great-grandfather of the minor, and upon his death, it was distributed amongst his family members. On the death of the father or the minor child, he became owner of the part of the land. Thereafter, the heirs in the family decided that the property be given to a developer, which would get money and also flats within the development in exchange. Therefore, there was an agreement between the family members and the developers. In order to give effect to the agreement, the mother applied for permission from the court, which was rejected by the concerned court as well as the High Court. The Supreme Court discussed ex ante and ex post principles and the various subjects where they are invoked. It also held that Section 8 of Hindu Minority and Guardianship Act is ex ante and discussed the provision at length. The court enumerated the principles of Section 8 deducted from various judgments of apex court. It also discussed the principle of parens patriae, or parents of the nation, and its application over the years and in the current legislations. It held that welfare supersedes all else as the governing standard in such cases. It held that in assessing the merits of any transaction, the court must evaluate the likely advantages against the risk. It said that even where guardian consents to the arrangement, as in this case, the court must ensure that safeguards are in place to protect the minor's interest. The safeguards are not intended to restrict the legitimate rights of adult co-owners, but to preserve the minor's stake in the property in a manner. After applying the aforesaid principles in the present case, the court said that though the share in the undeveloped land signifies ownership in law, but such an interest may yield no benefit for years and may be difficult to realize or monetize and may be encumbered by disputes or delays. It said that the mixture of an illiquid and liquid assets grant balance to the holder imbued with flexibility, which in certain cases may collectively be better than owning a part of an undeveloped land. Therefore, they allowed the appeal filed by the mother of the minor child give if necessary permission, but with certain conditions, that the amount which shall be received as part of the development contract shall be kept with the bank on auto-renew till the minor attains majority. It also said that there should not be any change in the development agreement without the approval of the concerned court. It also said that if the co-owners of the flat are desirous of selling their share at a time prior to the minor attaining majority, they shall inform the court and seek its permission.